India Legal presents Court This Week.
Hello and welcome to Courts Roundup this week. I'm Isha. In this special edition, we bring you the top stories of legal proceedings from the courts, from lower and subordinate courts to high courts and the Supreme Court. We bring a selection of major legal proceedings which made headlines in this week. In the next half an hour, we will inform you and update you on all important proceedings. So let's begin Courts This Week.
India Legal presents Court This Week.
The Supreme Court has asked the Allahabad High Court to monitor the ongoing CBI probe into the Hathras gang rape and murder case. As regard to the plea for transfer of trial outside state of Uttar Pradesh, the CJI-led bench stated that the question of transfer is left open until the investigation is completed. The bench also took note of the submission of the Solicitor General of India that the order passed by the Allahabad High Court had disclosed details about the victim and her family members. Based on that, the court requested the Allahabad High Court to remove the facts disclosing the details of the victims and her family from the order.
The Supreme Court has ordered that all aspects of the Hathras gang rape case would be considered by the Allahabad High Court. The bench of Chief Justice of India, S.A. Bobde, and Justice A.S. Bopanna and V. Ramasubramaniam also refused to comment on the merits of the case in its order. The order was passed in a batch of pleas praying for an independent probe into the shocking gang rape in Hathras, followed by the police alleged forced cremation of the victim's body in the dead of night without the consent or presence of her family. The petitions and applications that were taken up for hearing together also prayed for the trial to be transferred out of the Uttar Pradesh, preferably to Delhi. Another request made was to ensure adequate witness protection for the victim's family. The court had earlier sought to know from the state of Uttar Pradesh the steps taken on the aspect of witness protection. In its affidavit filed in response to the question, the state government gave details on all the security arrangements made for the victim family, coupled with the installation of CCTV cameras. Some interveners urged the court to direct the deployment of Central Reserve Police Force (CRPF) personnel for security on the ground that the state police was accused of having a role to play in the incident. While the Director General of Police (DGP) did not oppose to the request, it was prayed that should the prayers be allowed, a message should not go against the state police. The UP government had maintained that it is not treating the case as an adversarial litigation. The court was also told that the family had chosen to engage two lawyers to represent them, but had requested for a government lawyer to also be appointed. This submission was made in the affidavit after it was alleged in court that the soliciting of legal services was being done by some lawyers. The order on these issues was reserved on 15th October. Pertinently, the Allahabad High Court had taken suo motu cognizance of the midnight cremation of the victim. During the course of the hearing before the Supreme Court, the bench headed by CJI Bobde had also mooted as to how the scope of the case before High Court can be enlarged. It also opened that the case must be heard by the High Court first. Bureau Report.
Centre has filed in its reply in the Supreme Court in the loan moratorium issue. Centre has informed in its affidavit that a difference between compound interest and simple interest will be deposited in the account of borrowers by November 5th, and the affidavit comes after Supreme Court had pulled up the Centre for delay in implementation of their decision for providing benefits to small borrowers. The central government has filed a detailed affidavit before the Supreme Court in connection with the loan moratorium case, stating that the difference between compound interest and simple interest will be deposited in the account of borrowers by 5th November. This decision was taken by the Ministry of Finance and has been approved by the Union Cabinet in its meeting held on 21st of October. The centre said in its affidavit that the Ministry of Finance has approved the policy of interest waiver scheme for borrowers of specified loan for a period ranging from March 1st to 31st of August. The bench of Justice Ashok Bhushan, R. Subhash Reddy and M. R. Shah had heard a batch of petition raising issues pertaining to validity of RBI's 27th of March circular, which allowed lending institutions to grant moratorium on payment of installments of term loans falling due between March 1st, 2020 and 31st of May this year due to the pandemic. The amounts shall be credited by each of the lending institution, irrespective of whether such eligible borrowers have fully availed or partially availed or have not availed of moratorium such as deferment in payment of installment, the affidavit stated. The affidavit submits that the decision came to be approved by the Cabinet on 21st of October, and pursuant to this approval, the Finance Ministry has now issued the scheme. As per the scheme, the lending institution will credit the difference between compound interest and simple interest for the 6-month period in respective accounts of the borrowers, irrespective of whether the borrower has fully or partially availed the moratorium announced by the Reserve Bank of India on 27th of March 2020 on the repayment of loans. The affidavit comes after Supreme Court had pulled up the centre on 14th October for its delay in the implementation of their decision for providing benefits to small borrowers who had taken loans of up to 2 crore rupees. The Supreme Court is scheduled to hear the loan moratorium petition seeking a direction to waive interest on November 2nd. Bureau Report. The Supreme Court has stayed the Uttarakhand High Court order directing CBI probe into corruption allegations against Uttarakhand Chief Minister Devendra Singh Rawat. A bench of Justices Ashok Bhushan, R. Subhash Reddy and M. R. Shah observed that the issue required consideration. While issuing notice and sought response from the respondent, Uttarakhand High Court order had directed the Central Bureau of Investigation to file an FIR and investigate the allegation of corruption levelled against Uttarakhand sitting Chief Minister Devendra Singh Rawat by an investigative journalist Umesh Sharma.
The Supreme Court has stayed the Uttarakhand High Court's direction to register an FIR against Chief Minister Devendra Singh Rawat after allegations of bribery were made against him by a journalist. The bench of Justice Ashok Bhushan, R. Subhash Reddy and M. R. Shah stayed the High Court judgment passed on 27th October. Appearing for Chief Minister Rawat today, Attorney General K.K. Venugopal stated that the High Court had erred in ordering a Central Bureau of Investigation probe against the CM, who was not a party to the case, he said. The CM was not a party in this case and the High Court ordered a CBI probe. This is against Supreme Court verdicts which disallow destabilizing the government, as such verdict demand resignation of the CM, which is happening. Senior advocate Kapil Sibal, appearing for the journalist who levelled the allegation against the CM, stated that the matter is serious as there are WhatsApp messages and bank account links to the allegation against Rawat. Senior advocate Mukul Rohatagi, who also appeared for the CM, submitted that the High Court order was in violation of law. Justice Shah noted that everyone was taken by surprise after the High Court exercised its suo motu power under Article 226 when there was no such issue raised by the petitioner, Justice Bhushan observed. The court does issue notice in the petition after staying portions of the 27th October judgment. The matter will be heard after 4 weeks. The Uttarakhand High Court on Tuesday called for a CBI probe into allegation of corruption levelled against Rawat. It had also directed the police to register an FIR to investigate allegations of corruption made against the CM by journalist Umesh Sharma. While doing so, the court allowed a plea filed by Sharma seeking to quash an FIR filed against him this year for publishing a video containing these allegations. In a video released in June this year, Sharma had alleged that an amount of 25 lakh rupees was paid as bribe to Chief Minister Trivendra Singh Rawat by one Amrutesh Singh Chauhan for his appointment as chairperson of the Gau Seva Ayog Jharkhand. Rawat was the BJP state in charge of Jharkhand at the time, SESA 2016. This amount was alleged to have been deposited into various bank accounts, including those of Dr. Harendra Singh Rawat and his wife Savita Rawat. In his June 2020 video, Sharma asserted that Savita Rawat was Trivendra Singh Rawat's sister, making Dr. Harendra Singh Rawat his brother-in-law. The FIR listed various offences against Umesh Sharma for making corruption allegation, tying Dr. H.S. Rawat and Savita Rawat to Chief Minister Rawat in his video. Sharma was accused of cheating, forgery, conspiracy and allied offences. Finding that none of these offences are prima facie made out against Sharma, the High Court quashed this FIR. In the court of its judgment, the court also opined that there appeared to be mala fide intent motivating the case, giving the speed at which it was filed against Sharma, coupled with the facts that the allegation level in the FIR were within the notice of states as well as the informant much earlier in the year 2019. Bureau Report.
The Premier Court has said that cases of personal guarantors of corporate borrowers like Reliance Communication Chairman Anil Ambani would be transferred at one place. Only then will the verdict be given. The court also said that those who have filed cases in various high courts challenging the bankruptcy proceeding need to be transferred to one place. A bench of Justices L.N. Rao, Hemant Gupta and Ajay Rastogi favoured the transfer of all the pending writ petition challenging provision of IBC on insolvency of personal guarantors and reserve its verdict.
The Supreme Court has agreed to transfer to itself a batch of petitions challenging Insolvency and Bankruptcy Code (IPC) provision relating to insolvency of personal guarantors. The bench of Justice L. Nageshwar Rao, Hemant Gupta and Ajay Rastogi, after a brief hearing on issue of transfer, had reserved its order yesterday while expressing its inclination to allow the plea. The court said that no further writ petition on the issue are to be entertained by any High Court. Further, all interim orders passed by the High Courts will continue to be in operation till further orders. The matter will now be taken up on 2nd December, by which time all pleadings are required to be completed. The Insolvency and Bankruptcy Board of India (IBBI) had sought the transfer of all the matters pending before the High Court to the Supreme Court so as to avoid conflicting ruling by different constitutional courts. This position of IBBI was voiced by Additional Solicitor General Madhavi Diwan during the hearing yesterday. Solicitor General Tushar Mehta, representing State Bank of India, submitted that the issue under question in the various writ petition is a national issue and does not affect the writ petitioners before the High Court inter se. Thus, the apex court must hear the question of law, Mehta submitted. Of the pending writ petition, the maximum number of pleas remain pending before the Delhi High Court, before which the matter is expected to be taken up for final hearing on 10th November. The Delhi High Court had also passed an interim order in that batch of petition, which also includes a petition by Anil Ambani. While some counsel for various respondents argued in favour of the High Court deciding the issue first, there were some who proposed that the pending matter from the Madhya Pradesh High Court and the Telangana High Court may be transferred to the Delhi High Court, which is already seized of the matter. A submission was also made questioning IBBI's stance in seeking this transfer. In its petition seeking transfer of these pending cases, IBBI has submitted that various writ petitions have been filed in more than one High Court, which raise substantial questions of law of general importance. All of these pending writ petitions challenge the constitutional validity of Part 3 of the IBC, which deals with insolvency resolution of individuals and partnership firms. Section 95, 96, 99, 100 and 101 also have been assailed to the extent of being applicable to personal guarantors. The rules framed by the central government in 2019 under the IBC also stand challenged. Bureau Report.
The Shapoorji Pallonji Group has sought a formal separation from Tata Group in the Supreme Court, proposing that its stake in Tata Sons be swapped for a pro-rata stake in the Tata's listed companies. The two conglomerates have been embroiled in a legal battle since 2016 when Cyrus Mistry, second of family, had said that the control of the SP Group was sacked as chairman of Tata Sons. The Saporji Paloniji or SP Group, which is the largest minority stakeholders in Tata Group, believes it is necessary to separate interests from the auto to steel conglomerate.
The Shapoorji Pallonji Group has filed an application before the Supreme Court detailing a separation proposal seeking division of assets and share in listed entities of Tata Sons. This separation plan filed before the Supreme Court highlights that Tata Sons is a company comprising two groups, which the Mistry family's stake stand at 18.37% of the equity share capital, seeking to sever the decades-old association with Tata Group. The Shapoorji Pallonji Group has sought a pro-rata division of all assets. Shapoorji Pallonji Group has also sought a direct stake in all of the listed entities of the Tata Group and is seeking a pro-rata share of the brand value to be adjusted for net debt. The application also proposes the valuation of all the unlisted assets to be done by a neutral third-party agreeable to both the sides. Shapoorji Pallonji Group backs its proposal for separation in its application. The proposed separation, the SP Group says, is different from a buyout under Article 75 of the Articles of Association, which provides for a forced transfer of shares, an inherently oppressive measure. Through its proposal, however, SP Group claim that there are benefits for both sides. This considering there would be no valuation dispute in a scheme for proportionate separation of assets, while the control would remain in the Tata Group. The Mistry family's stake in each of the listed entities would stand at less than 10%, except in Tata Consultancy Services (TCS), where it is likely to be little over 13%. Moreover, a largely non-cash settlement would also be quicker to implement with minimal disruption to the operating companies. The scheme for separation is proposed on the apprehension that the SP Group's interest as minority shareholders will not be protected in Tata Sons in the current environment. Questioning Tata Sons' action thus far, SP Group claims that the company has made it clear that it would go to any length to prejudice SP Group's interest, which laid down the groundwork for the Mistry family seeking the division. The appeal filed by both Tata Sons along with its various entities and Director Emeritus Ratan Tata as well as Cyrus Mistry against the December 2019 decision of the National Company Law Appellate Tribunal (NCLAT), through which Mistry was reinstated as the Executive Director of Tata Sons, remains pending before the Supreme Court. The court, while agreeing to hear appeals by Tata and a cross-appeal by Mistry, had clubbed the litigation together and will hear the same at length. Earlier this year, the Supreme Court had asked Shapoorji Pallonji Group to maintain status quo as regard pledging of its share in Tata Sons for raising of funds. Tata Sons had opposed such a pledging on ground of having the right of first refusal. The Tata Mistry dispute, which reached Supreme Court in January this year, is likely to be taken up for hearing on 2nd November. Bureau Report.
And Riya Chakrabarti has filed her reply before the Bombay High Court in the plea filed by Sushant Singh Rajput seeking sisters seeking quashing of FIRs registered against them and alleged that since the late actor died 5 days after obtaining an oral prescription from sister Priyanka and her friend Dr. Tarun Kumar, it is imperative that the action of petitioners are investigated as well. Riya Chakrabarti has filed a reply in the Bombay High Court highlighting that actor Sushant Singh Rajput died days after he obtained a prescription from medicines from his sister Priyanka Singh, who were prescribed by Dr. Tarun Kumar. As such, Chakrabarti has called for the dismissal of the plea preferred by Priyanka and Meetu Singh, both Rajput's sister, to quash the FIR filed against them and Dr. Kumar in relation with the unnatural death of Sushant Singh Rajput. The FIR was filed on a complaint by Chakrabarti. In her reply, Riya Chakrabarti accuses Priyanka and Meetu Singh along with Dr. Kumar for allegedly conspiring to obtain false prescription to administer certain drugs to Sushant Singh Rajput, including those mentioned in Narcotics, Drugs and Psychotropic Substances Act. Chakrabarti has made detailed submission on her relationship with Rajput and her strained dynamics with his family. She goes on to submit that Rajput had been diagnosed and was receiving treatment for bipolar disorder with her support. On June 8, however, it is submitted that Chakrabarti came to know that Priyanka Singh had given a list of medications for Rajput, which were not earlier prescribed by the doctor he had consulted. Chakrabarti adds that she told Rajput not to consume this medication, more so given that his sister has no medical qualifications. Days later, on June 14, Rajput passed away. She goes on to raise concern that the medication prescribed to Rajput days before his death were prescribed by Dr. Tarun Kumar, even though there was no consultation as mandated by law. Chakrabarti submits in her reply that the actions of Priyanka, Meetu and Dr. Kumar should be investigated to find out how they could provide Sushant Singh Rajput with bogus and unlawful prescriptions. Chakrabarti has submitted that the FIR registered is not in contravention of Supreme Court's direction that the Central Bureau of Investigation should investigate all cases pertaining to the death of late Sushant Singh. Chakrabarti also notes that she has been facing anger and hate since the demise of Sushant Singh on account of Rajput sisters. In view of this submission, Chakrabarti has urged that the High Court should not quash the FIR and that it should dismiss the petition against the FIR with cost. Bureau Report. Punjab Haryana High Court has given important instruction on honour killing cases. The court has said that fast-track investigation by SITs is needed. The court has called for details of pending cases related to honour killing.
The Punjab and Haryana High Court has directed the Director General of Police, DGP Haryana, to file an affidavit regarding the number of honour-killing cases registered in the state in which trial or probe is pending, and which steps have been taken to fast-track the same. The bench of Justice Arun Kumar Tyagi has further asked the state DGP to spell out the steps taken for the protection of the survivor wife or the husband and other important witnesses in the completion of the chain of circumstantial evidence incriminating the accused responsible for commission of the heinous offence. The FIR was filed regarding the abduction of Sunita Rani and Dharambir. It was lodged by Rai Singh on 1st June 2018. Dharambir was subsequently murdered by the person who had abducted him. Notably, the case involves allegation of honour killing of Dharambir by person whose honour was allegedly subjected to disgrace by the deceased by performing marriage with their relative Sunita Rani. Statements of Sunita were recorded under 164 of CRPC twice, and she had also named the person with whom her husband, Dharambir, was last seen by her. The court noted that no effort were ever made for her protection despite the fact that she was an important witness against the accused, all or most of whom were her relative. The police has stated in its reply that 15 accused were involved in the present case in the commission of the offences mentioned above, out of which 12 accused have been arrested so far, but 3 accused, namely Nekiram, Balwant and Sher Singh, are still absconding despite expiry of more than 2 years. The court further noted that there was no mention in the reply as to what steps regarding getting them declared as proclaimed offenders and attachment and sale of their properties have been taken. Court's order, the High Court cited the Apex Court's ruling in the case of Bhagwan Das vs State of Delhi, wherein the court had noted that there is nothing honourable in honour killing, and they are nothing but barbaric and brutal murders by goated person with feudal minds. In our opinion, honour killing, for whatever reason, come with the category of rarest of rare case deserving death punishment. It is the time to stamp out these barbaric feudal practices which are a slur on our nation. This is necessary as a deterrent for such outrageous, uncivilized behavior. All persons who are planning to perpetrate honour killings should know that the gallows await them. Lastly, the court directed that copy of the order be sent to the Director General of Police, Haryana for requisite compliance. The DGP has to submit the relevant detail by 10th November. Interestingly, a two-judge bench of Supreme Court of Pakistan, comprising Justices Qazi Faiz Esa and Sardar Tariq Masood, had recently opened that the killing of women in the name of honor had never been an honorable practice and that such murder should not be categorized as honor killings. Bureau Report.
That's it for Coast Roundup today. Thank you for tuning in. Keep watching APN for more updates from around the nation.
India Legal presents Court This Week.